Chair Durbin, Ranking Member Graham, and members of the committee, thank you for the opportunity to testify today. I'm Sophia Lakin, the director of the ACLU's Voting Rights Project. Last week, on the 59th anniversary of Bloody Sunday, we honored John Lewis and the civil rights activists in Selma, Alabama, who risked or gave their lives to secure the right to vote. Their courage, sacrifice, and determination led Congress to enact the Voting Rights Act, or the VRA, one of the nation's most successful pieces of civil rights legislation. But nearly 11 years ago, in Shelby County versus Holder, the Supreme Court gutted the VRA's most powerful provision, the preclearance system that stopped discriminatory practices before they took effect in places with the worst records of discrimination. This decision unleashed a flood of discriminatory voting laws across the country. Nearly 100 restrictive voting laws have been enacted since Shelby, and just this past year, at least 14 states have enacted 17 restrictive voting measures. Over the past 2 years, courts have struck down racially discriminatory maps in Alabama, Georgia, Louisiana, South Carolina, and elsewhere. The ACLU and our many partners continue to utilize case-by-case litigation to protect voting rights. For its part, the ACLU has filed or intervened in nearly 100 cases to protect the rights of voters in Shelby. But this approach, including using what remains of the VRA, particularly Section 2, a nationwide ban on discriminatory voting practices, is woefully inadequate to address the enormity of the problem at hand. For one, unlike preclearance, voters can bring Section 2 cases only after a jurisdiction passes a discriminatory law. It also requires vast amounts of resources and time. As we know firsthand, this too often allows states to keep discriminatory rules in place during elections against the backdrop of slow court processes, irrevocably disenfranchising the very voters the VRA was designed to protect. The ACLU's 10 active Section 2 cases have been pending on average for 25 months, more than a 2-year federal election cycle. I want to highlight one potent and very recent example, undeniably showing that racial discrimination in voting is very much alive and well today. The only appropriate response is to restore and strengthen the VRA, including preclearance. In 2021, along with the Legal Defense Fund and partners, we challenged Alabama's discriminatory congressional map within days of its enactment and won an injunction blocking it 9 months before the 2022 midterms. But even though the 3-judge trial court held that the case was not particularly close, the Supreme Court put that ruling on hold during appeal. Ultimately, in its landmark ruling in Allen versus Milligan less than a year ago, the Supreme Court agreed that the map discriminated against Black voters, violating Section 2. That's 11 years after a Supreme Court majority wrongly declared that things have, quote, changed dramatically in the South. In Alabama, the very state from which the Shelby decision arose. But it took 16 months to achieve this win. And in the meantime, the 2022 congressional elections took place under the racially discriminatory map. It is impossible to remedy the gross injustice Black Alabama voters faced, having their voting strength illegally stifled despite every effort under what's left of the VRA. This is an egregious affront to the promise of democracy John Lewis and other civil rights giants marched and bled for. And even after the Supreme Court finally agreed that Alabama's map was racially discriminatory, the state drew a new map that defied the judiciary and continued to discriminate against Black Alabamians, trying to yet again appeal to the Supreme Court. And the fight in Alabama continues as I speak. While a new map is in place for the 2024 elections, Alabama persists in defending its discriminatory map for future elections. This is one example among many, and we cannot stand by any longer while Black, Latino, Asian American, Native, disabled, and other marginalized voters continue to be silenced. the promise of a fully inclusive, multiracial democracy hangs in the balance. Our current tools in this fight, while important, are simply not enough to combat enduring racial discrimination in voting. Congress must meet this moment by passing the John R. Lewis Voting Rights Advancement Act. Thank you, and I look forward to your questions.